take us off YouTube.
Not done.
Oh, who do we still have to do?
Is there any way you can run them to 8?
Mr. Bloom says he's gonna go today.
Monday, why not?
Hello, could you state your name?
Jeffrey Wayne Bloom.
Okay, Mr. Bloom, I'm glad you decided to see me. I understand your issue.
No, can I state why I didn't see you first of all?
It's okay. We already talked. I know why. Because you don't want to.
And because I'm I have meningitis or something, very serious illness.
Okay. Well, I'm not gonna hold it against you.
Thank you.
All right. So now I know you didn't want to meet with the public defender, and that's fine. That's your option.
Can I state part of that on record before we're finished? I don't want to interrupt you. I don't mean to disrupt the court or.
You may briefly, you may, okay, let's do it this way. Why don't I do what I need to do?
Yes,
Because
ma'am.
as you know, there are certain things that have to happen in an arraignment.
Yes, ma'am.
So why don't I work through that? And
Yes,
when I'm finished, if there's still something that you think it's important to put on the record, then I will happily listen to what you have to say. And let
Thank
you do that,
Thank
okay? All right, so let's start with your contact information. And do you use a phone number or email that you're willing to give me?
No, I don't have it.
All right, so
I'm not going to get a bond anyway. I'm not looking for a bond.
okay, all right. Good, because I probably was not going to give you a PR. So
Right.
good. So, all right. This is State of Michigan versus Jeffrey Bloom, 22 FB 1278. Now, would you like me to read you part of the arraignment is that you have the right to know what the charges are against you. Would you like me to read that on the record for you?
That's part of the issue I had with the public defender the last time, because all these charges were together, the resist arrest and all these charges. Now, Melissa Clean, I think her name was, she stated I told her from the very beginning, I do not waive anything. Okay, I've been through this several, I do not waive anything. She waived the right for me to have my charges read at court.
Yes. Okay. And
That was,
I'm just going to tell you, I understand your position, and I tend to agree that when you're a defendant, there's no reason to waive anything, but it is the policy of the public defender's office to not have people's charges read on the record. And part of that is privacy, because now everything we're doing is on YouTube.
right, I don't care. I know I'm not guilty.
But you know, lots of people do.
Yes, ma'am.
So,
Yes,
yeah.
ma'am. I mean, you can put that on that record. I've been to prison 7 times.
Okay, so your kimono is open, eh? Okay.
Who? Mine?
That's a joke. Your kimono, the kimono is open. Everybody knows what you're doing. Okay. All right. So I'm going to read you the charges. That's where we are now then. Okay.
Well, I'm not supposed to say stand mute or plead guilty or.
So for felony cases, technically you do not have to enter a plea at this stage at all, because the next part of the felony cases is determining whether the case will continue as a felony or be reduced to a misdemeanor or dismissed entirely. And so really no plea is necessary until that determination is made.
Well, that's another thing I want to state on record, but I'll let you do your job and then I can state on
All
record.
right. So you would like me to read you the charges?
Yes, ma'am.
Okay. The complaint in this matter states that on or about August 21st, 2022 at Bosun's Way in Ypsilanti Township, Washtenaw County, Michigan, you are accused, Mr. Bloom, in count 1 of criminal sexual conduct in the 1st degree during committing that criminal sexual conduct during a felony. You're accused of engaging in sexual penetration with during the commission of another felony, specifically strangulation. This itself is a felony that has a maximum penalty of life in prison, plus ancillary penalties like mandatory electronic monitoring, test, STD testing, DNA.
Which I should be the one getting tested.
Okay.
Right.
Count 2 is a charge of criminal sexual conduct in the 2nd degree causing personal injury. You're accused of engaging in sexual contact with another person, causing injury to that person.
What?
And using force or coercion to accomplish the sexual contact.
That's a homosexual guy, right?
I don't know.
That's a man, right?
The name sounds like a man's name to me, but I don't know. I don't have that in
They're
front
saying
of me.
I had sex with.
No, they're saying that you had sexual contact, which is touching.
Wow.
Felony, the maximum felony is 15 years in prison, mandatory testing, AIDS and STD testing. Count 3 is criminal sexual conduct in the 3rd degree, engaging in sexual penetration with using force or coercion to accomplish the act. That is a felony with a maximum of 15 years and mandatory AIDS and STD testing. Count 4 is a charge of assault by strangulation. You're accused of making an assault upon by strangulation or suffocation.
I thought they already said that.
That's a felony. Well, no, the first charge was committing CSC first during the commission of the felony. This is the felony that goes with that charge of CSC. This is a
Well, they gotta have proof of it. They gotta have proof of all this, though, right? I mean, like.
eventually, yes.
Okay.
Not at this stage. At this stage,
Okay.
it's a much lower burden.
Yes, ma'am.
Okay, that is a felony with a maximum of 10 years and or 5,000. Count 5 is assault by strangulation with an assault against by strangulation or suffocation. That's also a felony with a maximum of 10 years or 5,000. Count 6 is a charge of unlawful imprisonment. You're accused of restraining with a weapon or a dangerous instrument. That is a felony with a maximum of 15 years and or 20,000. And count 7 is a charge of unlawful imprisonment, knowingly or restrained. That's also a felony with a maximum of 15 years and or $20,000. All right.
Yes, ma'am.
Okay. Now, if you'd like to enter a plea of mute or not guilty, you may. It's not
Definitely
required.
not guilty. Definitely not.
All right. So now we talk about bond. And
You can give me any bond you want. I'm not gonna get out anyway. I've got the assault.
yeah, you already have a
Violation of probation.
okay.
Yep.
All right. There's a request from the prosecutor's office that bond be denied.
That's
The reason being that you are on bond, you have a bond on a.
No, I don't. No, I don't.
I'm
I'm not on bond.
My file says you have a 50,000 cash or surety bond set for you.
Oh, that I'm on bond?
That you're in custody with a bond in that amount.
Yes, ma'am.
Okay, so.
But I'm also in jail on a violation of probation with no bond. So,
Okay, oh, I see, okay,
yes, ma'am.
all right. I believe that your case meets the court rule to deny bond.
Yes, ma'am.
And my personal policy as the magistrate of the court is that typically because there are so few reasons when I can deny bonds that if someone actually meets the statute and the court rule, I typically do that.
Right.
Says something about the legislature's intent regarding danger to the community. So as I understand your current situation, this court rule is in fact met, and so I'm going to deny bond.
That's fine.
Beginning today, no contact with these 2 alleged victims.
I don't want contact. The woman was a woman in my life. I don't want to go into it.
Yeah, I don't want you to.
Okay.
Sometimes people call people from jail that they are not supposed to, so I just always ordered.
I did last time I did a week before I got out. She said I slapped her and she didn't, then she apologized or whatever. And
Yeah, I see.
stole my money. She does this all the time. She's done it 3 times now, Your Honor.
Okay,
But it's never been like this, but she's living in a crack house with this. He's a psychologist and I called her when I got out of jail and went to, she
okay.
said,
I don't want you to say something that will incriminate you, Mr. Bloom, so.
I'm not going to be incriminated. There's no way. There's no way they can prove this.
I've got one, but
No
I
possible.
don't want you to make a confession of some sort or something that can.
Well, I'm not working. I'll tell what I did. I always tell what I did.
I don't want to know. I don't need to know.
Yes,
All right.
ma'am.
Okay, I'm going to give you your court date, and then if you still feel like there's something you need to say,
This is for a preliminary examination, correct?
Next court date is the probable cause conference.
I have a right to a preliminary examination within 14 days, correct?
No, the court
Because
rule has
COVID is done. The COVID rule is finished.
No, the rule, it used to be a preliminary exam within 14 days, and then they added this first court date, which is a probable cause conference. You have the right to have that within 14 days. So yes, I'm scheduling your first court date within 14 days. It'll be on September 8th.
Okay. I don't understand. I was told that very recently that the COVID thing was done, that the preliminary examination is back to 14 days.
Nope.
Is what I was made aware of. Okay.
That's
what Mr. Kilowall told me.
I think that he just misspoke, because Mr. Kilowald has been around for a long time, and this PCC, the probable cause conference, is a relatively new development. So I think he just used the wrong name. So you're still entitled to that first court date within 14 days. And then the preliminary exam is supposed to be scheduled within 7 days after that.
Okay, well, Magistrate Cameron on Zoom, when he read my preliminary or my arraignment for my I got Parkinson's, Your Honor, so I'm kind of shaky.
I'm sorry to hear that, Mr. Bloom. You're doing fine.
And I'm ill with this meningitis or whatever it is, and I'm in a lot of pain. But anyways, I don't mean to use that for an excuse. I'm trying to do the best I can.
You're doing fine.
This Magistrate Cameron said that on Zoom that my preliminary examination would be held within 14 days. He agreed.
He's also a guy that's been around for a long time.
Exactly.
I can read you the rule if you need me to, but I'm telling you that the rule is the PCC within 14 days and the exam 7 days after that.
Okay. As a client of the public defender's office.
Right.
Okay? And I know that upon your court date, it don't matter what attorney's available, they can rotate any attorney to make you, for your attorney if you're a client.
Yep.
So there is a conflict of interest between me and the public defender's office, which Mr. Kilowall even agreed to.
Okay.
And he said, why wouldn't they? He said, why wouldn't they, Mr. appointed you? The reason they didn't is because Melissa Kleeman, last time at court, said that she didn't want the charges read over. So that way it gave the prosecution time to, because they dismissed those charges. They weren't going to bring those charges up. They was just going to charge me with resisting obstruction. But for some reason, and had a warrant. She cut her tether off and has a warrant forever, and she's done this to multiple people, and now she's living in a crack house with this.
Okay.
And she drinks a half gallon of vodka a day. She called me to her trailer.
Okay. Now, is this stuff that you need me to know and you need to have on the record? Because I feel like you're getting distracted.
Okay, I'm getting a little. I'm sleep deprived. I'm stressed out about many things, my mom, all kinds of stuff, okay? But this is really what I need. Lord Brown has stated that he threatened me. He said, well, how about this, Mr. Bloom? How about you get a competency? How about I refer you for a competency exam? And I spoke to Adriana Logman, Mr. Kilowald. I spoke to my CMH caseworker, and they says, man, there's no way you're incompetent to stand trial just by speaking to you face to face like you are. Mr. Brown did this as a scare tactic or a threat. And I believe that you, Your Honor, could, since these cases were together, you could just say, look, man, let Kilowald bind and put it all together,
I have made that exact argument in the past that I would like to be able to do that, because quite often we know that there's a conflict and somebody already has an appointed lawyer to handle a conflict on another case. And I've said in the past, the most convenient thing would be if I'm able to just appoint whoever is already handling, but that's the authority of the magistrate is less than that of a judge, and I am limited and can't do that. But I'll tell you what I will do for you, Mr. Bloom. I will send an email to Mr. Killewald and to Judge Simpson's court, letting them know that you were arraigned and your court date is September 8th, and that you have requested that Mr. Killewald be appointed because of the PD's conflict. I will
And
happily,
because of the prior case that's combined with this case.
I will happily do that for you.
Thank you.
Okay, and that, and then hopefully that can get set up so that your next court date is effective.
Right.
I can't promise you that part. All I can promise you is that I will send that email.
Yes, ma'am. You know, you seem more than fair. You seem like a very impartial, very down to earth, laid back.
I make an effort to treat all people that are in front of me with loving kindness and basic human dignity.
And I apologize for the way I look. I know I look horrible. I
You do
look.
not need to apologize. You
And
need
when
to apologize to me.
Marshall, they're all looking at this. They're probably looking like, look how ugly he is. But you know, I've been dealing with this for a few years now. We've been on and off, and this is, she steals my money and.
All right, do you, again, do we need to talk about all of that right now?
Well, I just, you know, the world, she's on probation. She cut her tether off. I tried to.
I can see that she has a warrant. I see that, but I can't do anything
There's
about
a half
that.
gallon back in the day and turns tricks for crack. She's sick in the head. She's
Okay.
living in a trap house where somebody, she called me over there and somebody OD'd. I had to save their life because they didn't even know how to do it. Now, she needs help, man. She lost her trailer. It was a brand new trailer. Now it's 7 months later. I'm not, she says I'm infatuated or something.
I'm worried about you saying too much about this case.
Okay, well,
and making admissions.
the prosecutor can use this all against, you know what I mean? They can word it the way they
Well,
want.
I'm not comfortable permitting that, okay? I'm going to protect you from, even if you're not willing to protect yourself from that, I'm going to protect
I
you.
know the truth. God knows the truth. So that's all we need to know. But one more thing. Mr. Simpson, why is he's just the probable cause. He's not the preliminary examination.
That's right. He handles all of the probable cause cases, and then the preliminary exams are divided up between
Right.
the
Okay.
7
Week to week.
judges. Mhm.
Yeah. Okay. If you can look at my record, Your Honor, I wish you would. I wish you would take a little bit of interest in this, because people like this shouldn't be allowed to do things like this over and over to people.
Okay.
When I've been in trouble and she's read all my police, she's a crime scene investigator type person. So she's read all my case laws.
Again, I don't want you to talk about this situation with her. I think that it would be inappropriate for me to allow you to continue to talk.
Okay, thank you, Your Honor.
I'm trying to protect you from.
Yes, ma'am, I understand.
But procedural stuff and questions like that, we can go ahead and talk about those things.
Okay.
Anything else?
Do I need to be tested? I think maybe I'm sick because of her. I don't know.
Yeah, I don't know either.
Now, I can't get medical here to do anything. They won't do any HIV or sex
And I
tests.
can't do anything about that because the jail does not work for me. So I don't have any authority to order the jail to do anything.
Okay. Well, I don't know. I don't know. Okay, Your Honor.
Okay.
So you'll try to get Mr. Killewald.
I'm sending an email right now while we're talking. I'm typing it. So it'll go out
Thank you.
before I walk away from my bench. I will have sent that email.
Arigato, have a great day.
And that is all that I'm able to do for you. And the rest is up to the next group. So, okay.
Thank
All
you.
right. Okay. Take care, Mr. Bloom. Thank
Good
you.
day.
Bye-bye.